Okay, so with respect to the legislation, the vehicle dealer, the legislation was passed in August of 2015. This new Consumer Protection and Business Practices Act replaced and modernized the Motor Dealers Act. The vehicle dealer regulations that fall from the Consumer Protection and Business Practices Act were implemented in February 1st, 2016. So with respect to the first topic I wanted to cover, it's material fact disclosure. So this is Section 522 of the Consumer Protection and Business Practices Regulation. So it begins in Division 2, which I believe is on page 38 of the regulations. And again, this is with respect to material fact disclosure. So what is a material fact? It's information that is known to the dealer or that the dealer should reasonably expect it to know that could reasonably expect it to influence a consumer's decision to buy or lease or refuse or buy or lease a vehicle. That sounds super confusing, doesn't it? So luckily, the vehicle dealer regulation sets out a number of explicit requirements for dealers to disclose with respect to vehicles' previous use, history, and condition. So essentially what this comes down to, before I move on to the explicit requirements, is that anything that would reasonably expect to influence a consumer's, want to purchase that vehicle. So if there's a fact that you think as a consumer would want to know about that vehicle that would influence their decision to buy that vehicle or refuse or buy that vehicle, it needs to be disclosed. So what needs to be disclosed? Well, with respect to new vehicles, whether the vehicle has sustained damage requiring repairs costing more than 20% of the asking price of the vehicle. So for example, if a vehicle has sustained damage during transport, if there was some vandalism on your car lot, those are required repairs that need to be disclosed. So I'll go through that again. So with respect to disclosure for new vehicles, so if the vehicle has sustained damage, repairing costs more than 20% of the asking price of the vehicle. So again, if the vehicle was damaged in transport, if the vehicle was damaged on your lot, and this is just with respect to new vehicles, if that damage, the required repairs cost more than 20% of the asking price of the vehicle, that needs to be disclosed. Okay, so consumers need to know that prior to entering into a contract with you. Okay, in the case of new or used vehicles, the location of the repair facility, if the facility is more than 80 kilometers from the dealer's premise. And remember, all dealers must have identified a location for repairs. So this is one of the requirements of the new legislation. It's a requirement when you do your filings. I know some of you may have done your filing, some of you are still working on it, and perhaps some of you haven't logged in yet, but these filings were due back in August 2016 for the transitional filing, and then your annual filing was due on your anniversary date. So identifying a location for repair facility, that's one of the items that you will have to provide once you do your filings. Okay, moving on. So with respect to prior use disclosure, so these disclosures are required in the case of all used vehicles. These are material facts that are set out in the legislation. So these are the explicit ones that I was mentioning earlier. So I'm just going to go through them point by point. So in the case of a used vehicle, these are the required disclosures. So a current printed VIN search must be provided prior to the consumer entering into the contract. So I think most of you know that online on SGI's website, there's a spot there where you can enter in the VIN number of a used vehicle. That result will show up and it'll show any of the claims against that vehicle expected damages. So the history of claims against that vehicle for Saskatchewan. So that printout is a required disclosure that needs to be provided to the consumer prior to the contract being entered into. That's important information that will influence, again, the consumer's decision whether or not to buy that vehicle. Another prior use disclosure is if the vehicle has been used as a taxi, a police or emergency vehicle, or an organized racing. If the vehicle has been owned by a rental company within the previous 24 months. If the vehicle is registered outside of Canada within the previous 36 months. Whether the vehicle has been brought into Canada for the purposes of resale, and whether the odometer of the vehicle either doesn't accurately record the true distance traveled by the vehicle, or it has been replaced or altered. So again, these are all required disclosures that have to be provided to the consumer prior to for them entering into the contract. Okay, so moving on. Also, what's required to be disclosed, and again, disclosure that's required to be provided prior to the contract being entered into, is that there's information that's available out there for consumers, and it can be obtained with respect to searches from other jurisdictions. So these information sources need to be provided to consumers. So there's a cross-Canada search. Excuse me, there's an RCMP VIN search. And as well as information needs to be provided to consumers with respect to Carfax or car proofs. And again, this needs to be provided prior to entering into that contract. So I mean, I think you guys see this. It's all about transparency. It's important that anything that you know or reasonably ought to know about that vehicle that would be considered a material fact needs to be provided to the consumer. Okay, and so providing disclosure verbally does not meet the requirements of the regulations. These disclosures must be in writing in a clear and comprehensible manner. And again, it must be provided prior to the contract being signed. I'm sure you folks are tired of hearing that already, but I mean, our office sees this time and time again, and I'm going to get into it a bit later in the presentation, but you know, we'll have a dealer that's come up against a complaint or an issue, and they'll say, you know, but I provided these disclosures to the consumer. I provided them to them prior to the contract being entered into. But they don't have any proof. There's no evidence. The consumer's saying you didn't provide it, and the dealer's saying, well, I did provide it, but the dealer can't substantiate the fact that they actually did provide it. So I'm going to get into a bit later some best practices, some tips, and things that you can do as a dealer to alleviate some of that risk. So again, just reiterating, material facts. So remember that you're required to disclose any fact about the vehicle's history, performance, or quality that might be expected to influence a reasonable consumer's decision to purchase the vehicle or determine a fair price. So you have the explicit, I think there were 6 there, explicit disclosures around, you know, whether in a previous jurisdiction, if it was used as a rental, a police, emergency vehicle, those are required disclosures. But then over and above that, you need to provide disclosure of this material fact. So you know, any fact about the vehicle's history, performance, or quality that might be expected to influence a reasonable consumer's decision to purchase the vehicle. Those need to be provided. Okay. So, for example, here's a couple of examples that would be considered material facts that needs to be disclosed prior to the sale. So, the vehicle's anti-lock brakes are not operational. Obviously, this is a material fact that needs to be disclosed. What happens if the vehicle's airbags are missing or they're not functioning? Again, this needs to be disclosed. What if the vehicle requires repairs? You need to detail what's wrong with it. It can't be fixed, or you chose not to fix it. Again, these things need to be disclosed. Is the odometer in miles? This is a good trigger to look into whether or not the vehicle has been brought up from the US. So you're purchasing a vehicle from an auction, or you're importing a vehicle. If you know, obviously, if it's imported from the States, if it's in miles, you need to disclose to the consumer that this vehicle is brought in from the US, specifically for the purpose of resale. What happens if the vehicle is used as a snowplow? You know, if I was a consumer, if I'm buying a vehicle and that vehicle was used as a snowplow, this is something that I would want to know if the dealer knew it. So again, it needs to be disclosed. If you as the dealer know that this vehicle was previously used as a snowplow. If the vehicle was damaged on your lot, so if say it was $3,500 in damage on a $10,000 vehicle, but however there's no insurance claim that was put in, and the dealer had fixed it internally. So therefore, it's not going to show up on the SGI VIN search, of course, because again, there's no claim put on it. However, it's still required to be disclosed. You know, it's on a used vehicle, so the 20% on the new vehicle doesn't apply, but it's on a used vehicle, and consumers are going to want to know that. They need to be informed. So those are all material facts. You know, I think the dealer should have a process in place to determine what needs to be done when they're taking a vehicle in on trade. What kind of mechanical condition is the vehicle in, and then those results needs to be disclosed. And I know that's a common practice out there, and many of you do it already, so that's good. But for those of you that don't, I mean, it's something that you should look at implementing. So pop quiz. I bet you didn't know there's gonna be a pop quiz today, but I have one for you. So, what do you think are the 2 most common disclosure issues that our office sees The first issue that our office sees time and time again is that the SGI VIN search is not provided to the consumer. This is an easy one for you guys to meet the requirement. The day the consumer is purchasing that vehicle, print out that SGI VIN search so it's current. Of course, this is required to be provided to the consumer prior to the deal being entered into, the contract being entered into. Our office sees vehicles being rejected because of this. I'm going to get into the remedies a bit later, but it's not uncommon for us to receive a complaint from a consumer where they've purchased a vehicle, they weren't aware of their rights or the disclosure obligations of the dealer prior to purchasing the vehicle, but they go home and they've heard something either was from a communications campaign our office has done, or perhaps from a friend, or however they heard the information, but they now understand that dealers are required to provide these SGI VIN searches. So they go in online, they run their VIN number. Holy man, my vehicle is a total write-off. I didn't know that. It wasn't something that was disclosed to me. And again, I'll get into this in a bit when it comes to remedies and what's of substantial character and what's not. But that's an immediate rejection. If that vehicle was a total write-off and it wasn't declared to the consumer or disclosed to the consumer prior to it being purchased, that vehicle will be rejected, and the dealership has to make that consumer whole. If it was disclosed, no problem. And if you can verify that it was disclosed, not a problem. Obviously, that's not a right for rejection. But if it wasn't disclosed and the consumer wasn't informed about it, then it would be rejected. The next disclosure issue that our office sees often is that there's no documentation to support that the required disclosures have been provided. So aside from the SGI VIN search, obviously those other material facts and the explicit requirements need to be disclosed. So again, our office sees this time and time again. I provided it to the customer, but I have no way to verify it. The fact is the onus is on the dealer to have supporting evidence, documentation to confirm that the required disclosures have been provided. We touched on this in a dealer bulletin that was sent out via e-blast back in January 2017. We indicated in that e-blast that dealers may choose a disclosure method that best fits their business. However, we also noted in that e-blast that during the course of our 2016 inspections that our investigators were doing, that we noticed some really good practices going on in the industry. And I see Susan had mentioned something here in the chat box, and it is good. You're right, Susan. It's great. You have to get that in writing. So good practice that we've seen out there is that dealers were using printed checklists that includes all the required disclosures, which is then signed and dated by both the dealer and the consumer at the time of purchase. That document on the dealer side would go into the vehicle file, and then of course the consumer would have their copy to take away. That way, if there's an issue that arises later on, the dealer can go back and say, no, I provided them the disclosures. Here's their signatures. Here's their initial. And keeping a copy of that checklist, it really does protect you from future complaints about non-disclosure. So it's easy. You can go through, write out the disclosure requirements on a checklist, and have that prepared, and just make that part of your business processes so that so that you don't get burnt. And whatever you decide to do, just make sure that it's clear and comprehensible. So here's something that we've seen. So this is an example of a stamp that I've seen on contracts, or on a contract at least, that a dealer was using in attempt to meet the disclosure requirements. So I'm not sure if you can see it. It's a bit blurry, but what it says is that the customer has received a car proof report and is aware of the vehicle history and previous province/country of origin. So this was a stamp that a dealer was using to try and meet the disclosure requirements that we just spoke about. So do you think that this meets the disclosure requirements that are set out in the legislation? No. I mean, the short and sweet of it is no. It doesn't cut it. I mean, it's not clear. It's not comprehensible. The specific disclosure requirements need to be stated in writing, and it must be clear. The example here, it's not clear and it's not specific. So it's an okay attempt, but it's good effort to try to meet, but it's not meeting, and it's not a good practice to use going forward. It's something that our office would take issue with. So if at the time the vehicle contract is entered into, a dealer does not provide disclosure as required by Section 522.2, so those are the required disclosure requirements that we just went through, or provides disclosure that the dealer knows or ought to have known, or it's false and misleading. So if the failure to disclose or the misleading disclosure is remediable and not of substantial character, the consumer may pursue damages for losses suffered. If the failure to disclose is of substantial character, the consumer may reject the vehicle and is entitled to recover the purchase price from the dealer, or to recover any reasonably foreseeable damages or any other losses that the consumer has suffered. Okay, so what does that mean? So if it's of substantial character, the vehicle can be rejected. Okay, if it's not of substantial character, so let's say a consumer buys a $20,000 used Ford F-150 from you, and they bring it home, and the SGI VIN search wasn't provided prior to the sale being made, and the consumer runs the SGI VIN search, and they find out that there's $3,000 damage. It was in an accident, and there was some damage to the front bumper. Okay, so that's not of substantial character. That wouldn't be that the consumer wouldn't have the right to reject that vehicle. But at the same time, there could be a point to be made about excess depreciation. Perhaps the dealer did take that into account when the vehicle is being priced. Perhaps they didn't, but the consumer would have an argument for a excess depreciation, and there could be some sort of negotiation made in terms of a payment back to the consumer because of that excess depreciation, because of that damage that wasn't disclosed. So these become tricky when it comes not of substantial character, because it's very case specific. It's not black and white. It's not cut and dry. When it comes down to it, the easiest thing to do to avoid this is just provide the disclosure, and then you're covered. So moving forward with respect to substantial character, this is the one that when consumers have the right to reject the vehicle, they can recover the purchase price from the dealer. So a breach of substantial character is any one of the 7 items here. This automatically triggers a consumer's right to reject the vehicle. So if the dealer fails to disclose any one of these 7 items on this list, that's an automatic breach of substantial character, which triggers the consumer's right to reject the vehicle. So let's walk through these 7. So if the vehicle was previously used as a taxi or a limo, the vehicle was used as a police vehicle, an emergency vehicle, or was used in organized racing. It was previously a rental vehicle. It was registered in a jurisdiction other than a jurisdiction in Canada. It was brought into Canada specifically for the purpose of resale. It was previously a total write-off. And lastly, whether the odometer of the vehicle does not accurately record the true distance traveled by the vehicle, or it's been replaced or altered. So what does this mean when there's a breach of substantial character? So in its most pure form, it means you'll put the consumer back in a position as if the deal had never happened. So you're essentially going to unwind the deal and make the consumer whole. That being said, if it's circumstance specific, and at times there may be an element of depreciation cost for usage, so the consumer is not unjustly enriched. So the consumer comes back to you, a year after, and then they put on a significant number of kilometers. It's a breach of substantial character, but there's excess depreciation, there's kilometers, there's usage, there's things that needs to be taken into account, when that rejection is taking place. So in our legislation, there's not a specific number of months that states a consumer can only reject a vehicle up for the first 30 days, 60 days, 90 days. There's nothing in there that says that. So there is going to be calculations and things that take place. So I can imagine that there's a few of you out there that are thinking, wow, this is crazy. This is nuts. Rejecting a vehicle, over not knowing that the vehicle was previously a total write-off or it was an emergency vehicle. But I always think that, you got to understand that what would happen, let's say if your mom was the consumer or any one of these items were not disclosed when she purchased a vehicle down the street, what would you want to see happen? She bought a car. She found out that it was, again, it was previously a rental vehicle. The odometer was rolled back, or that it was previously written off. I can't imagine most folks, at least, saying, that's okay, no problem. These things happen. I mean, these are automatic rights for the consumer to reject because it's a breach of substantial character. So keep in mind when you're taking a trade-in, you should also be asking the same types of questions to the consumer. Consumer may or may not know, but you should know as much information about that vehicle you're purchasing from the consumer so that you can kind of keep that disclosure, that train or those records fulsome and kind of going forward. So again, it comes down to the dealer whether you know that any one of these items with respect to the vehicle exist, or you ought to have known. So a lot of these, if you're buying vehicles from auctions, there's a significant number of disclosures that need to be placed. So if you buy a vehicle that need to be provided to you, if you buy the vehicle from the auction and it's been indicated to you that this vehicle was previously a taxi, again, you got to pass that information on to the consumer. If you don't know, then then you can't disclose it. But if you do know, you have to know, or if you reasonably ought to have known about it, and you haven't taken steps to find out that information, again, it can be a cause for rejection. So again, failure to make any of these disclosures triggers a purchaser's right to reject. That rejection also cancels any other agreements under the contract, such as extended warranties, financing, etc. So the consumer, again, they're made whole. These things are unwinded. Okay, maybe I'll speak to this slide here with respect to trade-ins, and then I'll pause again to see if there's any questions out there. But what about trade-ins? So this is what happens with negative equity and some of the way the contracts are formed. But so dealer is not required to return the vehicle traded in under the contract, but the dealer must refund the amount paid for that vehicle or the amount of credit allowed for the trade-in under the contract. The contract has inflated the selling price by $3,000 and inflated the trade-in credit by $3,000. The contract should be canceled. Should the contract be canceled, the dealer would have to refund the inflated trade-in dollar amount. So, and there's some negative equity scenarios going on out there where folks are upside down, and just protect yourself. Demonstrate negative equity clearly on the contract. Okay. With respect to disclosures, it's important to understand that a consumer, in most cases, isn't buying a car from the auction itself. They're buying through the auction, and the auction is simply acting as an agent on behalf of the seller. The same disclosures, again, that I mentioned previously apply, are required to be provided. At times, the auction actually they do own some vehicles that are sold, so in that case, they're acting as the vehicle dealer firstly, and then they would be required to provide you with the disclosures, the consumer with disclosures, and if they're acting as an agent, you're providing those disclosures to the auction, and then they're in turn providing those to the consumer. Because in the end, the dealer selling the vehicle is still ultimately responsible for providing those disclosures and meeting their obligations under the legislation. So with respect to dealer transactions, so whether this is a vehicle that Joe's Plumbing as the dealer buying from X dealer out there, so the dealer to dealer transactions, or sorry, a business to business transaction, the legislation applies. Okay, when there's dealer to dealer auctions, ADESA is a great example. Dealer wholesale auction, the legislation applies. So those same disclosures need to be provided from the selling dealer through the auction to the buying dealer. Okay. So the same rights currently apply to the buying dealer with respect to rights against the selling dealer if there happens to be an issue with disclosure, minimum powertrain, and we're going to get into powertrain in a bit here. But it's no different whether it's a public auction that the dealer has to provide disclosures to the consumer, or if it's a dealer-only auction, those same disclosures need to be provided at dealer wholesale auctions. Okay. So again, it's really important that dealers maintain due diligence when they're accepting trade-ins from consumers. You should be inspecting those trade-ins, utilizing the vehicle history reports that are available to you, whether there's a Carfax or CarProof for the SGI VIN search. You need to obtain that history and disclosure statements. So you need to obtain that history with respect to that vehicle. You should also be obtaining disclosure statements from customers trading in the vehicle, so that they're providing you with the history that they know about the vehicle. So, Bob owns a vehicle for 4 years. The 6-year-old vehicle, Bob can disclose to you what's happened with respect to the last 4 years. You might not know the first 2 years, but he can disclose to you what's happened with that vehicle in the last 4 years. So those disclosure statements are useful so that you can, like I said earlier, you can keep pushing that disclosure train forward. So everybody knows where they're at with that vehicle.